Good morning. It's Wednesday, February 9th, 10:31 a.m. This is the second half of the Senate Natural Resources and Energy Committee's morning session. We are resuming our work on S-234, an act relating to Act 250, as well as we're also checking in on S-200, an act relating to Act 250 and the use of master permits. With Ms. And then when we have council back, we'll continue our walkthrough of the bill itself. So good morning, Ms. Holler. How are you? Good to see you.
I'm well. Good morning, everyone.
All right. The floor is yours, ma'am.
Okay, so Jen Holler with the Vermont Housing and Conservation Board, and appreciate being here this morning, and we'll speak to the housing related provisions and a couple others of S-234. I'll be looking through draft 1.1, which I think is the one that you're focused on right now, and then also offer a couple comments on S-200, which I believe your committee discussed yesterday, and then of course be available to answer any questions.
Great.
Does that sound like a good way to proceed?
Yes.
Okay, great.
Thank you.
So I first, just from a big picture, would say that I think it appreciated some of the changes to S-234 in your latest draft, and there are many, many sections that we think are good, good additions, and I'll speak to those. The last time I was before your committee, I talked primarily about priority housing projects because your focus at that time was around the housing provisions and what they meant and what are the implications, and this draft of the bill preserves those regulatory incentives to for private developers to include some number of affordable housing units within the developments, and we think that that's been an effective tool, and are pleased to see that it's still going to remain in place. I wonder if it might be useful to just remind the committee of something I know you all know, but that the incentives that are within Act 250 call for certain levels of affordability. So essentially 20% of the units, roughly, to be affordable in order to achieve that, essentially to not qualify as a development if you're in a designated area under Act 250. When the Vermont Housing and Conservation Board and other entities, when we provide funding for an affordable housing project, the levels of affordability are much deeper and more comprehensive than that. So I just thought it might be helpful to make that distinction. We would probably have many units that are affordable at 30, 50, 60, 80% of median. And in some instances, we do have projects that are mixed income. That's sort of the best practice, to have some apartments within a larger rental housing development that's affordable at market rates, some that are affordable at different levels down to even 30% or below, which is considered extremely low income. So essentially, if somebody receives a public funding or subsidy in a larger amount, then the expectations for affordability, deeper affordability levels, and also the terms of that commitment, perpetual affordability, are greater. But under the Act 250 regulatory piece, there's a different balance there. Okay. So I don't know if I should stop there to see if there's any questions. I think maybe you spent some time on that issue a day or two ago.
Sure. Yeah, please. Thank you. So it'd be helpful to understand. I think, what we're looking at in part is that if the release from Act 250, some people might regard it as a subsidy of sorts, like that you might have, you might save time and money in going through permitting, for instance. And we're looking at, well, what's the public benefit? And housing is definitely a public benefit. And then the question is, okay, we get a little bit into the whole thing of, would this have happened anyway as an entirely private project? Or are we increasing the public benefit by saying a certain percentage, 20%, for instance, will be affordable? Okay, so if that's the kind of give and take that's going on, then I guess part of what I don't understand is, does money that VHC brings to the table allow for the 20% affordable housing to be built? In other words, is the developer yielding something, or are you actually putting all the money in that brings that rent down to the affordable level?
I think it's probably both. So in some instances, a developer would be able to create a project where some of the units are affordable below 80%. And speaking of rental housing right now, without public subsidy, but there are a number of instances where they will partner with a nonprofit or will seek funding in order to make those units affordable at that deeper level. So it's a combination. But what it really absolutely does do is it initiates that conversation. And in instances where a developer is not able to keep the rents down, make the rents affordable at the deeper levels without public funding, they do come to us, and it allows there to be affordable housing in an area where there might not otherwise be.
Okay. All right. Senator McDonald.
They come to you, and what happens? They come to.
Well, what a private developer might do is they might look to either apply to us directly if it's some of our federal funding, or they would partner with one of the regional housing nonprofits. So, and then the regional housing nonprofit would develop a certain percentage of the units in the overall mix in order to deliver those affordable units. So an example of that might be in South Burlington's Newtown Center. There's a mix of private and nonprofit development, a mix of market rate and affordable. Another is Cambrian Rise. So Senator McDonald, I can see that I'm not answering your question.
Are you saying that a private developer can go to your organization and make a case to you that you should have the discretion or the ability or to recommend public dollars be spent on their project, on the project they wish to build? Is that what?
For certain sources of funding, yes. For certain of the programs that we administer, yes, that is the case. Typically, we work with the nonprofit housing groups.
Okay. So what I was looking the other day at the affordable housing that has often been mentioned, that so many units are set aside, but they're set aside for 15 years. And after 15 years, the landlords can, send them a note saying that you're evicted in a month, and then they can turn around and do market rates. Is that not correct?
So my understanding is that under Act 250, if the developer pursues a priority housing project and asks for determination that they meet that definition, so that therefore they don't qualify as development, to qualify as a priority housing project, they have to commit to 15 years of affordability. So I believe that's correct. If they have any other state funding or even federal funding that we administer, we require perpetual affordability. I believe the policy decision at the time was that if somebody is enjoying the subsidy in terms of that regulatory incentive, then the appropriate trade-off is to ask them, they're not actually getting money from the state or federal government. They're enjoying a benefit because they have a special consideration under Act 250 permitting, and the trade-off was 15 years of affordability, I believe was the policy decision at the time.
By whom was the policy decision?
By the legislature, whenever Act 250, the priority housing project provisions were last adopted, and I can't tell you when that was.
Thank you, Mr. Chair. We spent a good bit of time on the Act 250 part of the applications, and it seems that we have in the past endorsed affordable housing, which is transitory and can, after a few, you can have kids, they aren't even out of high school, and you can be evicted so that they can, go out and rent seek rents at the market level. And I wonder if we wish to continue that sort of thing.
Well, so let me jump in a little bit here. So when you say they can be evicted, I mean, that's sort of a harsh envisioned future for what happens after the end of 15 years. I don't know. I haven't heard any testimony that suggests that at year 16, there's a round of evictions and then new people come in. I don't know if they're just re-offered their rent at a higher rate, and if that turns out to be affordable, or it turns out to be sort of a de facto eviction because they say, well, I could afford 600, I can't afford 1,800, we need to move. But I don't think
Well,
there's.
maybe we need to take some testimony on that. Thank you.
Yeah. Okay, thank you. The other explanation I got in doing some work between meetings was that one of the reasons it's not perpetually affordable is that because it doesn't come with there are no dollars attached to the PHP designation. What you end up with is a different permitting experience, but you're not getting money, and therefore it's that money that actually buys you that perpetual commitment. So that was news to me, so I thought I'd just share that now. We will take more testimony. Okay.
Thank you. That's the point I was trying to clearly and effectively make. So yes, that's exactly how it works. So shall I go to the bill draft now?
Yes, please. Thank you.
Okay. Well, so I will just do some high-level comments and work through the different sections. So I just wanted to begin by saying VHCB supports sections 1 through 6. The municipal zoning section, we see these are thoughtful incremental changes that have been considered by a number of different groups that essentially reduce barriers to developing in areas where it really makes sense and where the state wants to see development. So we support those. I will call out a couple of them as being of particular interest to us. So that's sections 1 through 6. We support all of those and feel like those are good and important changes. I'll mention section 3, which relates to municipal land use permits, and it says that those permits will extend for 2 years before they expire. We think that's helpful. A typical housing development project can take, and again, this would apply not just to housing, but that's the perspective I'm speaking to today, that it can take 2 or 3 years to pull together all the funding and financing to get from concept to construction and completion on a housing development. So sometimes what happens is developers will go through the local process and then they have to reapply, which adds, as you've been hearing, time and money and uncertainty, even if the project has not substantially changed. So I just wanted to flag that as being something that we have heard as a concern among housing developers. The next piece that I'll speak to would be section 4, which is the changes to the priority housing project definition. And we support the change here around which changes the so-called thresholds for when a PHP applies. So the language here essentially says that 50 units or less, or 49 units or less, in communities with populations up to 6,000 would qualify as a priority housing project. We feel like that's a very useful change. You may recall that you heard some testimony from Elizabeth Bridgewater of the Wyndham and Windsor Housing Trust a week or two ago. She talked about a affordable housing project in a neighborhood designation, neighborhood development area in Putney, where they are needing to keep the number of units below 25. They have the ability to do more there, but they're keeping it below 25. There's in order to keep that project moving and to allow it to continue to qualify as a priority housing project. It's our perspective that if this is a smart growth area where it makes sense to put housing, if you can get another 10 homes there, and then it really makes sense to do that. I would also note that just because you can go up to 50 under the definition of priority housing project, as you know, that doesn't necessarily mean that units are going to be that. I mean, developments are going to be that big. You still need to have the market demand. You need to have the local need. You need to have the financing and go through the local approval process, which will all help shape the overall number of units. So I think that's a distinction to allow that this would to make too. So we feel like that's an important change. To go on to page 8 of your draft, where there are changes to the definition of mixed income housing. I would say this is truly a technical change. I know that probably puts everyone on alert just if I even just say that it's technical, but this is language that the Vermont Housing Finance Agency has put forward a couple years ago, and it's been passed, I think, in a few different bills that maybe didn't, the bills that haven't advanced all the way. Your committee took testimony on it, I believe, a couple years ago. It essentially updates these definitions to their current practices. And you could check with Maura Collins about that if you need to confirm, but this is something that the Affordable Housing Coalition, I believe the Department of Housing and Community Development, VHFA, VHCB all worked through and supported a couple of years ago. So it'd be good to include that here. I wonder if I should pause because that's really the municipal zoning section. So to see if there are any questions related to that before I have a couple comments on some other pieces of the draft.
So let me take a look. Any committee questions on Ms. Holler's testimony so far? Okay, let's keep going. Thank you.
So, Mr. Chair, just
Senator McDonald.
So we need to change the statute. So the statute requires the current practices that entity other than the legislature has put into place. Is that what we're being asked to do?
Here in this section that we were just talking about? Yeah.
Yes.
So, Ms. Holler, how would you answer that? And then I have talked to Ms. Collins outside of committee time, so I can chip in something, but.
Yeah, so my understanding is that Act 250 has relied on the Vermont Housing Finance Agency definitions for owner-occupied housing in Act 250 for a number of years. And the way VHFA talks about them, they no longer refer to purchase price limits. So this is an update to reflect their current approach. So essentially, yes.
So you can understand, Mr. Chair, that this is not what in high school you are taught is the process for passing laws, is that administrations go ahead and do things that are perhaps unchallenged or whatever, and then we're asked to change the law to make what they've decided to do lawful.
That makes so much sense. I think if I could offer that, I think one of the reasons that it was included here is because it differs by bedroom size, and it's actually quite a complex not complex, but it's a calculation that is more detailed than you usually find in state statute. And I think that's one of the reasons, because there's different prices for different bedroom sizes in different communities, different MSAs, and so I think maybe that was one of the reasons.
Right. Thank you for that. And we'll have Ms. Collins in, so from, I also think on their side that I'm not sure precisely what drove their change, but it included just the things that Ms. Holler was listing. So that it was the way the statute is listed, it's a relatively blunt calculation. I mean, it's not a nuanced calculation. It's just the purchase price. And whereas they use location and number of bedrooms. And I think there's also a federal side to how they use area median income adjusted for location in their calculation as well. So they just have a more sophisticated, nuanced math for how they define affordability at VHFA. And we were pointing at, we had a cruder metric that predated where they've evolved to. So I think what they're asking us to do is point to the metrics they use now, and then that will make affordability more appropriately design, make it more accurate. You know, what do you mean by affordable? Would depend by number of bedrooms, depend by where you are, that kind of thing. But yeah, I don't know why one moved without sort of asking the other and that kind of thing.
The administration's around all the time and is faced with challenges that we only face 3 or 4 months a year, and sometimes they get out ahead of us, and sometimes we say okay, and other times we go, hey, what are you up to? So
Okay, all right. So I'm putting down having Ms. Collins in directly to provide some testimony and clarify that for us. Thank you. Other things, Ms. Holler?
I would say yes. So the section on forest blocks, I would say we don't have a position, but I would only say that the goals here are consistent with VHCB's mission and the priorities that we consider when we are reviewing applications and projects for forest land conservation. So I'll just leave you with that high level comment on that section. I will next jump to, and thank you for letting me shuffle my papers here, to section 15, which has to do with prime ag soils. So as the committee knows, when there's required mitigation of prime ag soils, those fees come to the Vermont Housing and Conservation Board, and we use that for other conservation projects within that county. We have not taken a position on this particular piece related to the state-owned airports. It does seem to be pretty narrow, and I've heard some testimony elsewhere that suggests it's primarily for economic development purposes. We cannot speak to what this would mean around each state-owned airport and whether there's an opportunity for housing there or not. We just don't have that. I don't have that to offer to you today. I would say that while the funding does come through VHB and we use it for conservation, that's really not the main thing. It's helpful, of course. It's not a huge amount of money. It's about $250,000 to $300,000 a year, just to give you a perspective. But I think the more urgent public policy good or public good is the protection of those prime ag soils needs to continue to be important to Vermont, and we avoid losing those wherever we can. And as you can imagine, there are lots of conversations around how to support the ag sector, how to support our local food system, how to make sure that Vermont can support itself and people who want to work the land. And we have very good soils here in Vermont, and it's very much part of the HCB's mission to try to protect those.
Okay.
So we'd like to avoid losing them where we can, but understand that this proposal is fairly narrow.
So the 200,000 to 300,000 was for all prime ag soils. That's what you get.
Yes. It varies year to year, of course, depending on which projects move forward.
You're right, but
we budget roughly exactly. Yes.
Okay. Yeah.
Our budget proposal, which you'll see in your other committee,
Yep.
next week, we budget $275,000, knowing exactly what it's going to be.
Thank you.
Let's see. I don't know that I have any other specific comments to S234 at this point, but I can jump to S200 if you like.
Okay, not seeing any further committee questions on 234.
Okay. So S200, and so let me begin by saying I absolutely agree and have seen that the state designation programs have been powerful tools and effective for many communities, and they really do work to draw development into the areas where we most want it to happen. and I can also appreciate the appeal of a master permitting approach. And in some ways, you'd be sort of establishing a community consensus about what you want to have to happen in those areas, which could provide some certainty that would be helpful into the future. But what I can't speak to, and I think this might be an important thing to think about, is the interplay between how this master permitting process would work with the existing designated designation process and then local permitting as it exists now. I just don't have that level of expertise. Before I was at the Vermont Housing and Conservation Board, I did housing for Governor Shumlin at the Department of Housing and Community Development, and that includes the Division of Community Planning and Revitalization, which oversees the designation programs. And communities very much like those programs, but we did hear on a fairly regular basis that they felt like it could be complex or too complex. There are a variety of opinions. Other interests thought maybe they weren't stringent enough, but we did often hear from municipalities that the designation program process could be difficult or more complex than it needed to be. So I could imagine that there might be more concerns if you had a master permitting process that went along with it. So can see the appeal, can also see that it might be more it could add complexity to an existing system. And I would offer one thing for the committee to think about is that if you find that you don't get to a place where you want to advance the master permitting idea, and I think S234 has a report required on the designation programs and how to update them, perhaps this concept could be added within that as a consideration.
Senator McCormick, you're the lead on S200. Do you have any questions or observations?
Well, if I think what Jen just said, if that's sort of with an if we don't want to simply go forward with a master permit plan, then we should at least include it as one of the things to examine. If I understood you correctly, Jen. Yeah, you hesitated. Okay. Yeah, I'm hoping we're not at the point yet where we're deciding what to do about not doing the master permit at all. I would hope that's still under consideration. But I would hope that perhaps if we decide not to do it, that we would keep it on the back burner for the future.
So thank you both for that suggestion. And yeah, we're still, this is a live discussion, so no decisions made yet. The one thing is, I don't know if Ms. Holler, if you've ever been involved in any way or observed a community going through a master permit application process and earning that designation. And part of the reason, well, I'll stop there. Just, I don't know if you have sort of firsthand or secondhand knowledge of seeing a community gain a master permit.
I have not, and I could not speak to why it doesn't happen very often, but I would think that'd be important to understand. I suspect there's some barriers within that process, and my guess is, well, that's a terrible thing to do. I should not be guessing. I would say, I think one question to ask would be, do municipalities see the benefit of going through a master permitting process to be significant enough for them to undertake it?
Yeah. Well, and I think, so yeah, well, we did hear from VLCT yesterday. We have some sense, but maybe we would need to double back, talk to them and others to ask that question very specifically. The other part of the reason I'm asking is, well, one, I'd like to know the answer to that question. And I'm very conscious of timing, like the whole ARPA conversation lurks in the background on all our work right now. And if a master permitting process itself took I don't know how long it would take to get that in place, and then then how long it would take to get amendments to that permit to allow housing to happen, and could both things happen in sequence within the ARPA funding window? And
Well, I can say with certainty it would take some time.
yeah,
It always takes time at the local level to move through zoning and bylaw changes and permitting decisions and master planning.
Yeah.
So it would. And the ARPA funds have to be obligated by 2024. And of course, the expenses, the actual work has to be done by 2026, the end of 2026.
Yeah. Okay.
Which sounds a ways out, but it's really not that far away.
I can imagine there's a lot of steps from the idea to delivering a finished project.
Yeah.
Okay. Great. Well, that's very helpful. Anything else you wanted to share comments on? Anything else you didn't get to today that you would like to share with the committee?
Well, just thank the committee for taking their thoughtful approach and time to think through this. Balance is in the eye of the beholder, I'm sure. I think that Vermont has been very fortunate to have avoided at the state level and in most communities the kinds of battles between the environmental community and the development community that you see in other states that can sometimes end up in lawsuits and tie things up and prevent forward progress in many ways. And I think we have Act 250 to thank for that. And I think we have the state's thoughtful policies around where it's all about where you want to develop and where you want to keep it open. And I feel like that's the balance that you're working to achieve with your potential updates to Act 250 in a way that preserves the balance that currently exists. And I recall a quote that's attributed often to Governor Dean. Whether he actually said it or not, I don't know, but I hear it attributed him to a lot, that if Vermont's going to grow, and we do need to grow, it needs to grow up. It's not, if we want to protect our working lands and our landscape. And I think in some ways that's what your bill is trying to do by allowing communities to do infill and to do, more development in areas where it makes sense.
Okay. Well, since you see so many projects, I'll ask this question. It's not, you can say, yeah, not my job. But you just, that's interesting. Vermont's going to grow, it's going to grow up. It occurs to me how often we build projects and the limitation on number of stories means that the projects are smaller than might be, and then if you would just add 1 or maybe 2 stories more, because you already have the footprint on the ground, and the marginal cost of adding a floor is a lot less than having a single floor by itself, all the rest. Is that a conversation that you hear about, like that towns are warming up to the idea of having more structures that are 3 or 4 stories, that kind of thing, as opposed to so many things are 1 and 2, which kind of maximizes their footprint and minimizes the number of units?
Well, I know enough to say that you're absolutely right. It makes all kinds of sense to think about if you can add another floor, if you've got the footprint already established. I'm not able to answer your question as to how many communities are thinking about allowing more floors than they have in the past. I am very excited that the bylaw modernization grants that are being offered by the Department of Housing and Community Development, and that's actually based in part on some work that we help support with interest. You might recall the housing revenue bond. So there was a little bit of interest earned on that bond before the money got out the door. And we were determined to use that for policy to help support policy changes that were going to have an effect over the long term. We were able to use some of that to work with the department on their zoning for great neighborhoods model bylaw project, which is now led to these grants. And there are 41 municipalities that are looking at updating their bylaws now with an eye toward increasing density. So the department really could speak to Chris Cochran's the person, or Jacob Hemrick are the person that could speak to the extent to which that's involving more floors in buildings.
Okay. Well, thank you for that. All right. Any other committee questions for Ms. Holler? All right. Thanks again for coming in, and it's useful to hear from folks in the front line as we think about housing. So appreciate your work and appreciate your coming to committee.
Thank you very much.
For that committee, Ms. Schakowsky has joined us. I'd like to turn back to resuming the walkthrough we were doing yesterday. We may well be able to finish up the bill this morning. If Ms. Schakowsky, good morning. And I don't know how soon you have to leave. Well, I know you have a packed schedule. You have to be in more than one place. So,
I don't have to leave.
okay. So let's jump back in. If you can screen share and resume the walkthrough, that'd be great.
Sure. Hang on 1 second.
And I see Mr. Storo's name on the screen. Good reminder to all. So we'll be hearing from Mr. Storo before we conclude today, and that is to hear about a concern that he has with the bill related to, I think, liens, but let him speak for himself when we get there.
Okay. Can you see the amendment?
Yes, ma'am. Thank you.
Okay, so this is the strike all amendment draft 1.1. Yesterday we got to page. We got through page 9, the floodway criteria.
Right.
So on page 10, did you want me to, so on page 10 is language that hasn't changed. Section 6 is the municipal response to Act 250 requests. So this requires that if a municipality fails to respond to a request by an applicant within 90 days as to the impacts under Criterion 6 and 7, the applicant will be presumed to not have an unreasonable burden on Criterion 6 and 7, which are education, municipal, and governmental services.
And just so people know, I would say that that was a request originating with developers who were saying they wanted to have a timely response from municipalities on their own municipal level permitting.
So then the next sections deal with forest blocks. They haven't changed from the bill as introduced, although you have taken testimony. Did you want me to walk through this language that hasn't changed?
Yes, I don't think yes, we don't have to go, we can march right along, but I think just to make sure it's front of mind for everyone, exactly what we're talking about in forestry, that would be good. Thank you.
Okay. So section 7 is amending the definition section of Act 250. It is adding new definitions that would be used in the new Criterion 8C. So they haven't changed since the bill is introduced. Connecting habitat means land or water or both that connects patches of habitat within a landscape, allowing the movement, migration, and dispersal of wildlife and plants and the functioning of ecological processes. The connecting habitat may include features including recreational trails and improvements constructed for farming, logging, and forestry purposes. So this definition is used in the new Criterion 8C as something applicants will need to consider in their application for Act 250. Next, we have forest block, which means a contiguous area of forest in any stage of succession and not currently developed for non-forest use. A forest block may include features including recreational trails, wetlands, or other natural features that do not themselves possess tree cover, and improvements for constructed for farming, logging, and forestry purposes. And then there's this definition of fragmentation. Your current draft of Criterion 8C doesn't actually use fragmentation, so you may want to consider just deleting this definition because it's extraneous at this point. But fragmentation means the division or conversion of a forest block or connecting habitat by the separation of a parcel into 2 or more parcels, the construction, conversion, relocation, or enlargement of any building or other structure, or of any mining, excavation, or landfill, and any change in the use of any building or any other structure or land, or extension of use of land. However, fragmentation does not include the division or conversion of a forest block or connecting habitat by a recreational trail or by improvements constructed for farming, logging, or forestry purposes below 2,500 feet. Habitat means the physical and biological environment in which a particular species of plant or wildlife lives. Okay, so now into Criterion 8. So we're giving it its own header now: ecosystem protection, scenic beauty, historic sites. 8A is getting a title of aesthetics to reflect that it does deal currently with aesthetics. B is addressing necessary wildlife habitat and endangered species. That's an existing criteria, although it's currently called 8A. And then the new language dealing with forest blocks is down on line 13. So Criterion 8C, forest blocks and connecting habitat, will not result in an undue adverse impact on forest blocks and connecting habitat. If a project as proposed would result in an undue adverse impact, a permit may only be granted if its effects are avoided, minimized, and mitigated in accordance with rules adopted by the board.
Can you say something that helps me better understand what we accomplished in 8B versus, I know we're going to have 8C calls for a rulemaking around forest blocks and habitat, but how would you they're complementary in some way, but how would you describe to someone why we would have both? Is one species oriented and the other is more habitat oriented, or how do you describe that?
Yes. 8B is fairly particularized to a species. So this requires that so a permit will not be granted if it's demonstrated by an opponent that the development will destroy or significantly imperil necessary wildlife habitat or any endangered species. So there needs to be a demonstration that there is a species on the site that is either an endangered species, and that is, A&R, Department of Fish and Wildlife, has all that information. But then necessary wildlife habitat is broader than just threatened and endangered species. It's any species that is using the area as a necessary habitat. So it is required to be specific to species that are currently living on the site. 8C is more about, well, as originally conceived, was about fragmentation and the preservation and prevention of fragmentation of the landscape and the ecosystem itself. So they are different.
All right. Well, it doesn't seems as though one thing is we're setting a standard of an undue adverse impact as opposed to significantly imperiling wildlife habitat or an endangered species, which seems like a lower level of protection as I read it. And I just don't want to
Which seems like a lower level.
Characterizing.
Which is lower?
B.
No.
No, okay.
So undue adverse impact is a two-step process. It allows there to be an adverse impact, and then it asks whether or not it's undue. And so I mean, actually, I withdraw that statement. I do not know if it's fair to give an apples and orange with these analyses because there isn't analysis currently done for C. And so I don't actually know if it would be more or less strict, particularly because you're going to have to wait for the rules to be adopted anyway. But there is currently undue adverse impact standard under aesthetics. And so it does allow for adverse impacts to be created by a project and then just decides if it's too much.
Right. Okay. Well, and I think, so you're reminding me as we talk about C, that where we're headed with C really gets spelled out more in a more detailed way in the coming section, where we describe what kind of rule, what we're expecting that rulemaking to address. So, okay.
There is another dimension too, which I sort of glossed over, but the necessary wildlife and endangered species criterion, the burden is on the opponent to an application, not the applicant itself. So it's something that needs to be, the applicant needs to make their initial burden of proof by filing their application and providing enough information. But the burden is on an opponent to say that it's not, that the applicant is not going to meet the criteria. So that is different. As it's drafted right now, 8C is on the applicant. So that is a difference.
Right. Okay. Thanks for that reminder.
Okay, so then section 9 is the rulemaking section for criterion 8C. I will say that I'm not sure any other previous criterion has required rulemaking by the board. Normally Act 250 criteria are put in statute and the particularities are worked out in case law through the process. So this is a little bit different. I think there have been some instances where there has been rulemaking associated, but this is really putting a lot of the burden on the NRB to spell out the specifics in rulemaking. And I think that may have taken place with the prime agricultural soils process, and I can double check on that, but that is because it is very, there's a lot of detailed calculations that go into that one with calculating mitigation ratios. So I will just say that this language is a little bit unusual. So the Natural Resources Board, in consultation with ANR, shall adopt rules to implement the requirements for the new criterion 8C. Rules adopted by the board shall include how forest blocks and connecting habitat are further defined, including their size, location, and function, which may include information that will be available to the public to determine where forest blocks and connecting habitat are located, advisory mapping resources, how they will be made available, how they will be used, and how they will be updated, standards establishing how impacts can be avoided, minimized, or mitigated, including how fragmentation of forest blocks or connecting habitat is avoided or minimized, which may include steps to promote proactive site design of buildings, roads and driveways, utility location, and location relative to existing features such as roads, tree lines, and fence lines. Criteria to identify when a forest block or connecting habitat is eligible for mitigation. Standards for how impacts to forest block or connecting habitat may be mitigated. Standards may include appropriate ratios for compensation, appropriate forms of compensation such as conservation easements, fee interest in lands, and other forms of compensation. and appropriate uses of on-site and off-site mitigation. The board shall convene a working group to provide input to the rule prior to pre-filing with ICAR. The board shall convene the working group on or before February 1, 2023. The board shall file a final proposed rule with the Secretary of State and LCAR on or before June 15th, 2023. And so what this means is this criteria will not, there will be a delay in using this criteria because you'll have to wait for the board rules to come out in 2023. Section 10 adds language in section 127 entitled 10. This is holdover language that came out of H233. It's been in almost every draft, and it's about adding forest blocks to the A&R maps. So resource mapping, the Secretary of Natural Resources shall complete and maintain resource mapping based on GIS or other technology, as we are developing a more advanced technology from GIS. The map shall identify natural resources throughout the state, including forest blocks, that may be relevant to the consideration of energy projects and projects subject to Act 250. GIS shall be available. The Center for Geographic Information shall be available to provide assistance to the Secretary in carrying out the resource mapping. And then on page 15, the Secretary shall establish and maintain written procedures that include a process and science-based criteria for updating resource maps developed under this section. Before establishing or revising these procedures, the Secretary shall provide opportunities for affected parties and the public to submit relevant information and recommendations. Okay, section 11 is the road rule. So this is adding a new jurisdictional trigger under Act 250 under the definition of development. So this includes the small change that's highlighted in yellow that was recommended by Jamie Fidel. So the construction of a road or roads, driveway or driveways, which as a single road or driveway is greater than 800 feet, or which in combination is greater than 2,000 feet, to provide access to or within a tract or tracts of land of more than 1 acre owned or controlled by a person. So that is what triggers Act 250. And there's some additional qualifying language. For the purposes of determining jurisdiction under this subdivision, any tract or tracts of land that will be provided access by the road or driveway is involved land. As used in the subdivision, road shall include any new road or upgrade to a Class 4 highway by a person other than a municipality, including a road that will be transferred to or maintained by a municipality after its construction or upgrade. For the purposes of the subdivision, routine maintenance of a Class 4 highway or stormwater improvement required pursuant to 10 VSA 1264 shall not constitute an upgrade. Routine maintenance shall include replacing a culvert or ditch, applying new stone, grading, or making repairs after adverse weather. Routine maintenance shall not include changing the size of the road, changing the location or layout of the road, or adding pavement. For purposes of determining the length under this subdivision, the length of all roads and driveways within the tract or tracts of land constructed within any continuous period of 10 years after October 1, 2020 shall be included. This subdivision shall not apply to a road constructed for a municipal, county, or state purpose, a utility corridor of an electric transmission or distribution company, a road located entirely within a designated downtown or neighborhood development area, or a road used primarily for farming and forestry purposes, unless used for residential purposes. So your committee worked on this language extensively during the H926 process 2 years ago. So a lot of the changes that were added in this committee. But you're talking about private roads that are for a residential purpose that are either 800 length for a single, 800 feet in length for a single road, or in combination, 2,000 feet in length.
Thank you. Any questions on that one? All right.
So then section 12 adds new language related to wood products manufacturers. Again, this language was in H 926. So first we're adding definitions in the Act 250 definition section. Wood product manufacturer means a manufacturer that aggregates wood products from forestry operations and adds value through processing or marketing in the wood product supply chain, or directly to consumers through retail sales. Wood product manufacturers include sawmills, veneer mills, pulp mills, pellet mills, producers of firewood, wood chips, mulch, and fuel wood, and log and pulp concentration yards. Wood products manufacturer does not include facilities that purchase, market, and resell finished goods, such as wood furniture, wood pellets, and milled lumber, without first receiving wood products from forestry operations. So we're talking about businesses that take products from forestry operations, but not retail sellers that purchase completed goods and resell them. These are businesses that take in raw materials and add value to them. Wood product means logs, pulpwood, veneer wood, boltwood, wood chips, studwood, poles, pilings, biomass, fuel wood, maple sap, and bark. So then on page 18, there's language that hasn't changed, but this is adding specific language in Act 250 related to permit conditions for these wood product manufacturers. I did just want to flag that currently Act 250 permit conditions are not set in statute. There's no required permit conditions for any application. So the fact that this bill is going to add specific permit conditions for specific industries, this is a new change. This has not happened before. So this would be the only industry that has specific permit conditions. So permit conditions on a wood products manufacturer. A permit that sets hours of operation for a wood products manufacturer shall only be imposed to mitigate an impact under Criterion 1, which is air and water pollution, Criterion 5, which is traffic, and Criterion 8, which is aesthetics. So what that largely translates to is Criterion 1, air pollution, includes noise pollution that has an impact on human health. Criterion 5 is about traffic flow, but Criterion 8, aesthetics, also in this context would largely refer to noise. So both 1 and 8 are related to noise. If an adverse impact under Criterion 1, 5, or 8 of this section would result, a permit with conditions shall allow the manufacturer to operate while mitigating these impacts. A permit with conditions that mitigate these impacts shall allow for deliveries of wood products from forestry operations to the manufacturer outside permitted hours of operation, including nights, weekends, and holidays, for the number of days demonstrated by the manufacturer as necessary to enable business operations not to exceed 90 days per year. So I did just want to take a step back again and talk about permit conditions. Permit conditions are a tool that the district commissions have the option to use. When someone puts in an application for Act 250, they have to demonstrate that they will meet the 10 criteria of Act 250. The district commission then has the option to approve the permit, deny the permit, or approve the permit with conditions, preventing it from being denied. District commissions are only allowed to attach conditions to mitigate specific issues under specific criteria. So the language on lines 15 through 18 largely feels extraneous to me because they shouldn't be attaching permit conditions that aren't tied to a specific criteria anyway. Permit conditions are intended, they are designed to mitigate impacts under criteria. That is their purpose. So this would be allowing extended hours of operation outside of normal business hours, nights, weekends, and holidays. And I also find this language to be a little bit confusing because it seems to contradict itself, where a permit condition shall allow a manufacturer to operate while mitigating these impacts, but then saying, even if the impact would be operation outside of normal business hours, including nights, weekends, and holidays, the business will be able to operate on those days.
So if, as you think about that, if you, I think you know the committee's goal underneath this, and if not, then we're happy to try to express it more clearly, but I'd welcome alternative language if you thought it accomplished the same end, but in a better expressed form.
I have provided input on this language in the past, and I potentially have some rewrites available that you have considered in the past. But I'm not sure that they actually would address your concern, your intentional goals. So we can talk about that.
Okay, thank you.
On to page 19. Permit with conditions on the delivery of wood heat fuels. A permit with conditions issued to a wood products manufacturer that produces wood chips, pellets, cordwood, or other fuel wood used for heat shall allow shipment of that fuel wood from the manufacturer to the end user outside permitted hours of operations, including nights, weekends, and holidays, from October 1 through April 30th each year. Permits with conditions shall mitigate the undue adverse impact while enabling the operations of the manufacturers. So I have the same concern here. I think that technically the first sentence and the second sentence conflict, because if in fact the undue adverse impact under the criterion is the fact of the operation outside of normal business hours, this just completely overrides that. I do think that that is the intention that was part of the request as this was requested. So it's just it just is a little bit odd to say mitigate the impacts, but operate during this period, even if there are impacts.
Okay. Well, I could imagine, for instance, that you might operate during those sorts of times, but you might not turn on every light in the log yard or leave your truck running for 2 hours. You know, I mean, there would be things you could do that would make your outside of normal business hours delivery more or less noisy or visible or all that kind of stuff. But anyway, I don't want to go into the weeds. It's kind of like how to be a good neighbor. It's what's at heart.
So then finally, there's language allowing the permit amendments to happen. So wood products manufacturers holding a permit may request an amendment to existing permit conditions related to hours of operations and seasonal restrictions to be consistent with this section. Requests for condition amendments under this subsection shall not be required, subject to Act 250 Rule 34E. So 34E is the current process by which an applicant has to request an amendment to their permit for permit conditions. So this is saying that process isn't needed. They have the automatic ability to request these permit conditions.
Thank you. For things that remain that we've walked through recently, I don't think we need to do the same level of detailed read through. I'm just thinking of, for instance, 1 acre towns, but let me just check with the committee. Does the we talked about this recently. Does anyone want to rehear the 1 acre town provision?
Right, so this is very short. This is the language that would address the concern raised by the Supreme Court's Snowstone case.
Okay. And we, so the question here on primary soils at an airport, I think one thing I want to make sure, I've had the impression, but let me check while we're in the neighborhood here, that this is for land already owned by an airport. So is there any provision here that means if say they own 1,000 acres right now, and then they acquire 200, and 3 years from now, they acquire 200 more adjoining. Can they do that and not be subject to the prime soil provision?
Yes, this is a forward-looking provision. So generally speaking, if a person already holds an Act 250 permit and then they purchase later additional land and construct on that land, they will need an Act 250 permit amendment, during which they'd have to go through the criteria analysis. And so this is forward-looking, so it would apply to future mitigation.
Okay. And I'm guessing that every airport is significant enough that it probably holds an Act 250 permit, unless somehow the state exempted itself.
I don't know the answer to that.
Okay. Could you find out whether our state-owned airports hold Act 250 permits, please? Thank you.
I'm sure B-Trans could probably tell you more quickly than I could. One other caveat to this, it does actually also contain language on line 19. The notwithstanding 1 VSA section 214 also includes provision that would allow any currently pending applications for Act 250 permits or permit amendments at state-owned airport. So normally, as I just said, everything is forward-looking, but this would extend to any current applications as well.
Okay, thank you.
But did you need me to walk through this? I know you've just been discussing it. This is just saying state-owned airports do not need to mitigate reduction or destruction of primary agricultural soils.
Okay, thank you. So I'm going to flag for myself wanting to think with committee mates about the forward-looking nature that means that this is not only for current footprints for airports, but if they choose to expand, that the same would apply. Because I think I've been misrepresenting it a little bit by saying it's for land currently owned by an airport and therefore probably highly unlikely to return to agricultural use. But if an airport decides to expand, there are some that adjoin land and farming. Okay, is my understanding, right? So thank you.
Right, and I just want to add that is not actually like the policy purpose of this. It's not. Yeah, the goal of 9B, yes, is to potentially preserve primary agricultural soils for use in the future, but it is also to save other primary agricultural soils in place of the ones that are being destroyed, because 9B does allow for soils to be destroyed as long as others are protected. So it's about, yes, development is allowed to continue as long as that development is recognizing that they are taking soils out of circulation and they need to preserve them elsewhere.
Right, okay. So, right, thank you for that. So in other words, they have no such obligation under this provision.
Correct.
Yeah. Okay. I think you I don't know, we talked briefly about this before, Environmental Division, Superior Court.
Sorry,
Any
Senator
position?
Westman, did you have a question?
I would just say to the chair, I think we just need to get a handle on what this would all mean. If what we're talking about is the line item of $275,000 a year that gets paid in to mitigate prime ag soils, and these 10 airports are some subset of that number, it can't be a very big number that they're paying that would come out of these airports to. But I don't know. So the idea of how much prime ag soil do we think there is around these airports? What does that mean? Transportation, somebody from the airport division should come in and tell us. And it would be helpful to know what developments are we looking at around the state at the 10 airports.
Okay. We will ask someone in. Thank you. Okay. We just did this one the other day when Senator Brock was in. So I think we can, unless there are questions about adding a temporary position at Environmental Division.
I did just want to flag a couple of small issues here. First, I haven't verified that ARPA funds can be used for this purpose, and I can reach out to JFO and see if they've done any analysis for this. I don't know if temporary judges are a qualifying expenditure, but also I am not familiar with ever adding temporary judges. This is a little unusual. While I can appreciate the connection between having another judge would potentially allow the permit appeals to move faster, I don't know if there's a you'd have to appoint a temporary judge, and then they just wouldn't be a judge anymore. Hiring a temporary person versus appointing a judge is different. So I've just never seen this before.
Okay. Thank you.
And then so section 17 adds the language from the, is it S278? Actually, I'm not sure on the number here, but this is Senator Bray's bill asking the NRB to look at whether there should be different jurisdictional triggers for agricultural businesses. So I think I can quickly, do you want me to quickly read through this?
I think we're all set. I mean,
Okay.
S235 was the number. I just had to look it up myself.
Sorry.
Okay. And we would take testimony on it as well.
You did take testimony on it?
No, I'm saying we,
Oh.
before
you will.
moving it, would take
Oh, okay.
testimony. We haven't had any.
Okay, and then, right, so the designated area report in section 18, I don't think your committee has reviewed this language. This is the language from H511 that's in the House. It's appropriating $150,000 to the Department of Housing and Community Development to hire an independent consultant to evaluate the state designation programs. So they'll hire this consultant to review and assess the state designation programs and incentives established in Chapter 76A that recognize and invest in the vitality of Vermont's compact settlement areas, and conduct statewide stakeholder outreach and support to support the evaluation of and future improvements to the program, including participation by state, regional, and municipal advocacy and non-governmental organizations. The consultant shall make recommendations on how to objectively define and map existing compact settlements as a basis for broader recognition, improve the consistency between and among regional plans and future land use maps, modernize these programs, including consideration of program reform or consolidation, make the designation programs and associated benefits more accessible to municipalities, apply regulatory and non-regulatory benefits, strengthen designation and incentives as a platform for place-based economic development, climate action, complete streets, and equity and efficiency of public investment and service delivery, implement the smart growth principles in 2791, and achieve the goals of 4302. On or before July 15th, 2023, the consultant shall submit a written report to the General Assembly with its findings and recommendations for legislative action. So this, I think I mentioned this in the committee before, the state designation program was not originally created to have anything to do with land use or Act 250. The program was created to have a simple way to award incentives and tax credits to areas of economic development. So they have increasingly been used over the years as proxies to line up with places where designations, exemptions from Act 250 may be useful. So that wasn't the original goal. And at this point, there are 5 designations. It is a little bit complicated. They all have different requirements. So this is looking to hire a consultant to do outreach across the state and then provide feedback on how the program should be consolidated and rewritten and modernized.
Thank you. I think that brings us to 19, which you walked through us previously. There are no changes there, are there? Right?
No.
Okay.
Yeah.
And last is 20 effective dates.
Yep, so I added an effective date because the primary agricultural soil language related to airports in that bill was to take effect on passage.
Okay. All right. Thank you for the tour. Senator McDonald.
It's a pet peeve, Mr. Chair. What does modernize these programs? What does modernize mean? Update?
Can you point me to where you're seeing that word?
Page 23. C, about 5 lines up from the bottom.
I agree. It's not very descriptive,
Yeah.
but I do think there was intention from the sponsor, DHCD, as well as general concern that these programs are now being used for something they were not originally designed to do.
Mm-hmm. So what does modernize mean?
I don't know. There's actually a couple of phrases in there that I find very annoying as well. And so I would be happy if you would like to wordsmith them.
Okay, thank you. Thank you.
Wordsmithery is always invited. All right. Okay. Well, thank you very much for taking us on a tour. There's between the tour and the testimony in the last 2 days, there's a lot to think about.
Can I add one small point that I don't think I said yesterday? Just quickly, this is completely within your purview, but the first few sections that are being added that are from Title 24, I do think you may want to be careful that they could be subject to a germaneness challenge because they are not directly related to anything in the underlying bill. I think you could make an argument that they might be related, but I did just want to flag they're a little bit in the gray area because they are not in fact changes to Act 250.
Okay.
The report that we just discussed also I think is arguable, but if you added the phrase Act 250 in there, I think you can make a stronger argument because the designation programs are being used in Act 250, but the other things are purely municipal zoning changes.
Okay. All right. Well, thank you. Good to be aware. The connection, even as you pointed out, these were about incentives, designations to earn incentives, but they've become proxies for planning. And given that the heart of the bill is around planning and land use, I would hope someone might be flexible in their interpretation of germaneness, but we'll see. I don't count any of those chickens till they've hatched twice these days. If that's possible. Okay. Well, thank you again. So I'd like to turn to batting cleanup today. Mr. Storrow, thank you for coming in, and thanks for your patience. Love to hear what you have to share with the committee around S234.
Thank you, Mr. Chairman and committee members. Chuck Storrow, Leonine Public Affairs. I'm here on behalf of Connecticut Attorneys Title Insurance Corporation, that from here on out I'm going to refer to as CATIC. Basically, the subject of my testimony is the road rule provision in Section 11 of the strike call that Ellen just went over. It's Section 12 in the bill as introduced. And I want to say at the outset that CATIC does not have a position on the merits of whether or not there should be a road rule aspect to Act 250 jurisdiction. What I'm going to be talking about is more pretty dry and technical in nature. Just to back up a little bit, CATIC is a title insurance company, and notwithstanding its name, it's actually domiciled in Vermont, meaning it's organized under Vermont law, and its primary regulator is the Vermont Department of Financial Regulation. It is headquartered in Connecticut, however, but it has an office in Williston. I believe it has the largest market share of title insurance in Vermont. Title insurance is insurance that ensures the marketability of title. It is usually required by banks in connection with mortgage loan transactions, whereby there's insurance in place that ensures the bank's title interest in property. People can also buy title insurance that runs to their own title interest in property. It's usually paid for by a one-time premium that's paid at closing. Title insurance policies are based on an attorney's examination of the land records in which the subject property is located, basically a title search. In the 90s, the Vermont Supreme Court in a couple of decisions decided and held that when an attorney certifies marketable title, they have to address the issue of whether or not the subject property is in compliance with things like Act 250 and local zoning. And this creates a little bit of a problem when it comes to Act 250 jurisdiction under the road rule, because you could have a vacant piece of property that isn't developed, and then after the effective date of this legislation gets developed with a road that would trigger that Act 250 jurisdiction under the road rule, there's no way you would necessarily know when you look at the title to the property that there is such a road that was created after the effective date of this legislation on the property. So it really, you're kind of flying blind when it comes to the issue of can you render an opinion on whether or not the property is subject to Act 250. So our proposal is basically that the Department of Environmental Conservation be directed to amend its wastewater and water supply rule to require people who apply for a wastewater and water supply permit to indicate whether or not there is a road being constructed in connection with that project, and that the permit, and if so, what the length of that road is, and that the permit reflect that information. And the reason why that would be helpful is that those wastewater and water supply permits are recorded in the land records. And basically, a permit, a wastewater and water supply permit is going to be required in any scenario where there's a construction of a structure that requires plumbing. And since the road rule would not apply to the construction of roads used for forestry or agricultural purposes, it's really going to get at, having this sort of paper trail created in the land records via the wastewater and water supply permitting program is really going to get at all the situations where somebody who's building a road in connection with a project that requires plumbing, that's going to get at pretty much every instance where that property needs an Act 250 permit based on the length of the road. So I've submitted some proposed language that would require, this rulemaking process by the Department of Environmental Conservation. And I should mention, and I believe it was in 2020, H 926 is, I believe, I recall as being the bill number. There was a similar Act 250 bill that contained a similar road rule provision in it, and I, made the same pitch back then. At that time, it was the Department of Environmental Conservation in ANR was amenable to what we were proposing. I have submitted what I'm talking about today to folks at ANR and the Department of Environmental Conservation. I have not heard back from them one way or another on our proposal, but I do recall that they were okay with it back in 2020. So that's the nature of the situation, and that's the ask. Happy to take any questions.
Thank you. So if someone were purchasing a parcel large enough that does not have a road, and it's large enough that you could construct a 800 or 2,000 foot road driveway, I'm going to sell that parcel to the next person. It's unimproved, and I sell them to them as unimproved. Are you saying that the person I'm selling to should know that if they were to choose to develop, that the 800 or 2,000 foot road rule could be could obligate them to participate in Act 250, even though at the time of sale it's unimproved? I'm just trying to see who's failing to get what piece of consumer protection information.
Sure.
When.
No, that's a good question, Senator. It's actually, it would be the person who's purchasing it would want to know whether the property is already in compliance with Act 250. And in particular, let's say the bank that's going to grant a mortgage to the person who's purchasing it, let's say that the property was a vacant parcel of land, but then after the enactment of this legislation, the seller builds a house and needs a wastewater and water supply permit. So if somebody's now buying a house on a 900-foot road, there's no way that you could tell from the land records that road is there. And so, when you tell the purchaser, this property is in compliance with Act 250, you don't know that unless you can tell whether or not there's a road there. So if there was a permit that said there was a road of a wastewater and water supply permit that indicates that there's a 900-foot road that was built in connection with building that house, then, and you don't see an Act 250 permit in the land records because those get recorded, then you say, oh, they never got an Act 250 permit when they did that road and they're not in compliance. And what, as a practical matter, happens then is this process of certifying title and having to address compliance with Act 250 is actually an enforcement mechanism, because then the seller goes, oh, geez, I didn't know I needed an Act 250 permit. I better go out and get one on an after the fact basis. So it actually causes a higher degree of compliance because there's this mechanism associated with transferring title where this issue gets looked at, and then the parties have to deal with it. They have to solve that problem in order for there to be clear title.
Okay. So this seems like it's not particular to the road rule alone. Other people could do things that should have been permitted by Act 250, but for whatever reason, went ahead, developed on their own property and never got the permit. And
That is
record-
true, but the practical sort of aspect of it is that this would first of all, it would capture to a large extent, the issue of compliance with the road rule aspect of Act 250 jurisdiction. The other sort of jurisdictional triggers in Act 250 is the creation of lots, the number of lots, over what period of time that gets created. And that is something you can figure out from the land records, because you would search back 40 plus years and you could see whether there was subdivision activity. If this parcel of land that you're looking at came out of a larger parcel at some point in time after the enactment of Act 250, you can then, count how many lots were created out of that larger parcel of land by looking at the deeds by the person who subdivided it. The other aspect of jurisdiction is the construction of improvements for commercial or industrial purposes. And yes, there is a degree of risk associated with that, because you wouldn't necessarily know that somebody built an improvement for commercial or industrial purposes on a property by looking at the land records, although in most cases you will be able to figure that out, because in towns that have zoning, it's likely that there would be a zoning permit for that. The grand list might reflect that. So this isn't a perfect, in all cases solution, but it just, if the Act 250 jurisdiction is going to be increased by virtue of the road rule, this minimizes the risk or mitigates the risk of not being able to determine whether the property is in compliance with Act 250 under the road rule angle of jurisdiction.
Okay. All right. Thank you. That's helpful. And I guess, it's just, there are other jurisdictional triggers, and I'm wondering how, while we think about this one, not that we should try to solve every problem in the world, does this address other jurisdictional triggers that were overlooked and then therefore unrecorded, and therefore make it harder to have a complete and a thorough title search? So I guess
you can think about that, Senator, and see if there's some proposal we could make in that regard. But I'm basically at this point reacting to the idea of enacting the road rule.
Sure.
Jurisdictional trigger, which, as Ellen mentioned, that was in place, up until 2002, and it did cause problems back then in terms of determining compliance.
Okay. Well, thanks for bringing that to our attention, and thank you also for offering language and doing some legwork on it. If we go forward on that piece, then we'll have to check in with DEC and see what gets them, learn more. With that, I just want to thank everyone for coming in this morning. Thank you, committee, for hanging in an extra 5 minutes. Sorry to keep you over. We try to adjourn on time. Happily, I don't think we have any noon meetings that I know of for the Senate. And with that, we are adjourned. Tomorrow is a Thursday. LCAR is meeting. So we are